Well, the Supreme Court is taking up the question of same-sex marriage once again. All of these questions follow hard upon the Supreme Court declaring, in the Obergefell case, of course, that same-sex marriage must be elevated to the level of traditional marriage. In fact, marriage must be redefined as not between a man and a woman for the purposes of producing children. Instead, marriage will now be defined as two people of any sex living together under the boundaries of the law, essentially. Monogamous, non-monogamous, doesn't really matter. As long as it is two people of any sex, that is the new definition of marriage, according to Justice Anthony Kennedy in a 5-4 majority in the Obergefell case. Well, this bears a lot of consequences because when you redefine marriage, this now raises questions as to how much are people allowed to act in accordance with their own viewpoints on marriage. Because once the Supreme Court has declared a redefinition of an institution as fundamental as marriage, and once the Supreme Court has also declared that same-sex marriage is on a par with traditional marriage, and thus that anybody who does not believe that is in some sense a bigot, what exactly do you do with people who don't believe that, which for nearly all of human history was nearly all humans? What exactly do you do with all the people who do not go along with the idea that two men or two women being married to one another is the same thing as a man being married to a woman? What about religious people? Or what about people who aren't religious, who just believe that, for example, society has more of a stake in men and women being married to one another than it does in two men living together or two women living together, which is obviously and patently true. What exactly do you do with those people? And this has now raised its head at the level of the Supreme Court. So the Supreme Court looks as though it is going to move along the lines of what has been called the Utah Compromise. The Utah Compromise is set out in the state of Utah. Essentially what it does, it creates a very strict non-discrimination law that includes things like sexual orientation. And then it creates massive carve-outs for people of religious faith. So basically what it says is you are not allowed to, quote unquote, discriminate against people who are gay or lesbian. However, if you are a religious person, then we have a big religious carve-out for you, that you are allowed to act in accordance with your religion. That seems to be the compromise the Supreme Court is going to draw. However, is that going to be the long-term compromise that is accepted by the left? Of course not. Of course not. The left will not be happy until you personally are celebrating all of the activities they deem to be good and useful. That is the entire purpose of having government elevate same-sex marriage to the level of traditional marriage. After all, the benefits of same-sex marriage had already been granted to same-sex couples under the law nearly everywhere across the country with things like civil unions. So why exactly was there a push to elevate this to the level of marriage? It wasn't for legal purposes, because the government was supposed to be a godlike creation that now discerned what was good and what was evil, and anybody who crossed the government's view of what was good and what was evil must be punished by the great God of government. What we have here is not actually a secular worldview contrasted with a religious worldview. You actually have our two religious worldviews, a religious secularist worldview and a religious worldview, a traditional religious worldview. And the secular religious worldview is imperialistic. They believe that it is their job to make sure that you in your life approve of all the activities they say are good. And they're going to use the power of the law as much as they can in order to compel you to believe these things. Now, the Supreme Court as currently constituted is not going to do that. Likely 6-3, the Supreme Court is going to say that religious people are protected by the First Amendment to the Constitution of the United States, at least insofar as their creative practice of their art, for example. However, what this case really highlights, there's a case before the Supreme Court right now that was heard yesterday in oral argument. And this case was about a graphic designer in Colorado who's claiming a free speech right under the First Amendment to refuse to create websites celebrating same-sex weddings because of her Christian faith, despite a state law that forbids discrimination based on sexual orientation. This is basically a variation on the same case that we saw with Jack Phillips of Masterpiece Cake Shop, who refused to bake a cake for a gay wedding. And then, as soon as he refused to do that, and the Supreme Court said he is correct and okay in doing that, as soon as that happened, he was hit with, well, bake us a cake, a transgender celebration cake. And now he finds himself back in front of the Colorado woke commissars, being forced into re-education programs. This is the way that this battle is going to go. This is why you can't redefine fundamental social institutions along the line of secularism without also mandating the rest of it. Okay, there is no halfway solution here that the left is willing to accept, because what they really want out of all of this is not just tolerance and diversity. What they actually want is celebration. All of this ties into a broader belief about identity, which is that the true identity, the true you, is all of your sexual passions. And it's not enough for other people to acknowledge that you have those sexual passions. Those people must celebrate them, because otherwise they are denying your identity. And if they deny your identity, that is an act of discrimination. It's an act of cruelty. It's an act of bigotry. And it means that you are bad and you are mean and you are doing essentially violence to them. This is the philosophy that has taken over nearly all of the university system. It has taken over at a lot of major companies. And it is a philosophy that eventually will end up taking over in the law unless there is significant pushback from traditionally minded and frankly rational people in the United States who at the very least have to agree to some sort of compromise on this issue. But there will be no compromise with the left. That again, the entire goal here is celebration. The entire goal here is you will be made to care. You can say as much as you want because, again, people who are in favor of traditional marriage have been saying it for decades. Do what you want in the privacy of your own home. No one cares. That's your business. That's not enough for people. That's not what they want. What they want is for you to celebrate. What they want is for you to bake the cake, bigot. What they want is for you to create the website, bigot. What they want is for you to have to change your viewpoint about what is right and wrong, about any sort of hierarchy of acceptable moral behavior in the sexual realm. You're supposed to change all of that because they want you to change all of that. And if you don't, they're going to say that you are tantamount to a bigot who believes that white people shouldn't marry black people, for example. Now, all of this is part and parcel of a couple of major movements that have happened in the United States. One is the movement to obliterate the distinction between immutable characteristic and behavior. This is a general philosophical distinction that has been completely obliterated in the United States. So the comparison of sexual identity with race, for example, is completely specious. It is not the same thing whatsoever. The reason I say this is because race is, in fact, an immutable characteristic. This is why everyone still today, despite all of our wokeness, everyone still laughs when Rachel Dolezal, a white lady, claims that she is black. The reason everybody laughs is because that's absurd. You cannot be a white person who is black. That's not the way this works. It's an immutable characteristic. And if you discriminate, we have decided in the United States correctly on the basis of race, this makes you a bigot. Right? If you discriminate on the basis of an immutable characteristic, somebody is disabled, and you discriminate based on their disability. Not that they can't do the job, they're a person in a wheelchair, they can't be a firefighter, but you say that a person in a wheelchair can't be a coder at Facebook or something. We've decided that that is discrimination because that is discrimination, right? That is not the same thing as sexual identity. Why? Because sexual identity is inherently internal. It is a subjective feeling if you're talking about orientation. And if you're talking about anything other than orientation, namely behavior, behavior is behavior. Not the same thing as race. A black person who likes classical music and reads Shakespeare at night is still a black person. It does not make them white. A gay person who is married to a woman and acts in straight ways sexually, it's very difficult to explain how societally that is different from being a straight person. This is the whole point. The distinction between behavior and an immutable characteristic like race is very deeply drawn philosophically, but it's been completely obliterated in modern society where we say that it is exactly the same to say that somebody's sexual behavior is wrong as to say that somebody's race is wrong, right? Those are not the same thing at all. Say somebody's race is wrong, that makes you a bigot. Say somebody's sexual behavior is wrong, that makes you a traditional moralist because behavior throughout Western civilization has always been treated as a component of your capacity to make decisions about your own life. And people can judge those decisions and whether those are good or bad. Okay, so that is one distinction that has been completely obliterated. The other distinction that's been completely obliterated is the distinction between state action and private action. This is something that happened under the Civil Rights Act of 1965, and you understand the temporary necessity for it. Okay, in 1965, there was an attempt to destroy segregation in the United States correctly, to destroy racial discrimination in the United States correctly. However, what the Civil Rights Act of 1965 did is a couple of separate things. One, it said government can no longer discriminate because Jim Crow was, in fact, a government regime. Right? Jim Crow is a series of laws that existed in the states that mandated that restaurants, for example, have separate black and white areas. In Alabama, there are actual laws on the books mandating that if you were going to build water fountains, you had to have a black water fountain and a white water fountain. You had to have separate bathrooms. You had to have different restaurants. You had to have different components of the buses, right? All of this was encoded in state law in Jim Crow states. And so the Civil Rights Act came along and said, you can't do that anymore. Correctly. That is right. And first of all, it should have been unconstitutional for states to do that in the first place after the 14th Amendment. Put that aside. Civil Rights Act comes and obliterates that. Fine, good. That's exactly what the Civil Rights Act should have done. Then the Civil Rights Act goes further. And the Civil Rights Act says that individuals can no longer in their businesses discriminate. Now that is pretty clearly a violation of what the founders would have considered First Amendment freedoms, right? Freedom of association, freedom of speech, right? All of this would have been considered pretty basic freedom stuff. Now, two things can be maintained at once, as always. You can be free to discriminate, and also you can be a terrible person for discriminating. Those two things hold together very easily, actually. Right? Freedom of speech applies to Nazis. Nazis are evil. They say evil, evil things. They believe evil things. The First Amendment still applies to them. And so, freedom does not mean that I approve of all the ways you use your freedom. However, for the federal government to come in 1965 and say that private persons who are not the government are now forbidden by law from discriminating in quote-unquote public accommodations, for example, is a violation of constitutional freedoms, even if you like the outcome of that. And this is an argument that Barry Goldwater famously made in 1964, and then he was ripped up and down because, again, people made the dishonest argument that if you are in favor of the freedom, this must mean that you like all the ways that the freedom is used, which, of course, is the road to fascism. Because if you think that freedom is secondary on a governmental level, that freedom on a governmental level is secondary to how the freedom is used, meaning we only give you freedom if you use it in the ways that we approve, you don't actually have the freedom. The government just gets to tell you what to do each and every day. This is a point made by Christopher Caldwell in his book, The Age of Entitlement. There's been essentially a second constitutional bargain drawn by the Civil Rights Act of 1965 and the acts that came immediately afterward in terms of compelling private behavior that never would have been foreseen by anybody at the time of the founding or for most of Western history. The idea that the government could force you into doing these things in your private life. Alrighty, guys, the rest of the show is continuing right now. You're not going to want to miss it. We'll be getting into why the left wishes to use big tech as its weapon. Plus, we'll be taking your calls. If you're not a member, click the link in the description and join us.